Hey y'all, Rob here with ATX Legal, and today I'm going to talk about a recent case where we got my client's DWI dismissed pre-trial. If you have a pending DWI, this might be of interest to you. Now, of course, none of this is legal advice. The specific issue that I was dealing with in that case almost certainly doesn't apply to your case, but this should give you a little insight into the way you look at the evidence, try and find holes in the prosecution's case, and then once you find those holes, the way that you can exploit it. I haven't considered the specific facts of your case, so this is not legal advice. It's only for educational purposes. But if you would like legal advice, you can always visit us at the contact form linked below to set up a no-cost consultation. Now, let me first go over some of the facts of the DWI. My client was coming home from the Moody Center from a concert. It was late at night. He's driving on the highway. There aren't many cars on the road, but he does swerve a little bit. Swerve's probably the wrong word, but he does go over the lane line a couple times. And on that basis, the police officer lights him up, pulls him over, and begins a DWI investigation. You might already be familiar with what a DWI investigation looks like, but they gave him the standard field sobriety test. They asked him where he was going, had he had any alcohol, and at the end of it, they asked for a breathalyzer. Now, my client refused the breathalyzer, which is what you should do, but they did go ahead and get a warrant and took a blood draw, and that blood draw came back over 0.15, which is over the limit that bumps the Class B misdemeanor to a Class A. In addition to that, my client had a previous DWI conviction, meaning that if he did get a second conviction, it would automatically be a Class A as well, and another conviction down the road would automatically be a felony. So it was very important that, if possible, we keep this DWI off my client's record. So my client got stopped on a traffic violation. They pull him over. They do a pretty normal DWI investigation. The blood comes back over 0.15. Pretty open and shut case, right? Not so fast. The case came out while this case was still pending. The case hadn't been decided at the time of the stop. And if you're a law nerd and you're interested in reading that whole case, you can click my blog post down below where that case will be linked as well. But the case is called State v. Hardin, and in that case, the facts were very similar to the facts in my own. A U-Haul truck had gone over the line a couple times, and on that basis, the police stopped the vehicle. Now, there were some more serious charges involved in that case, but the basis of the stop was the same. And in that case, the Texas Supreme Court said that alone cannot be basis for probable cause for a stop, meaning just going over the line one or two times is not enough to provide the police with that probable cause that they need to pull the vehicle over. So now I have this favorable case law. What do we do with it? Well, we file a motion to suppress. And what that means is we're saying there's no probable cause, so we have to throw out all the evidence that came from that stop. That would include the field sobriety test, that would include the blood draw. All the evidence that was gotten from that stop would have to be thrown out, and you can imagine the prosecutors wouldn't have much of a case without all that evidence. So I filed that motion, I set it for a hearing, and then after a few back and forths on scheduling, we got the hearing scheduled. The prosecution subpoenaed the officer to come testify. Now, while that's going on, I did go to the prosecutor and say, hey, do you really even want to go forward with this case? Because if we can get it dismissed even before that hearing, that's a win. But in this case, the prosecutor wanted to go forward with the hearing. They presented their evidence, and in large part, the police officer testified exactly as we thought he would. He said that my client went over the line, and it was on that basis that he got pulled over. But the officer threw a curveball, and they'll often do stuff like this. He decided to testify that before the dash cam video clicked on, and despite the fact that it wasn't written in the report, he said that my client was speeding. Now, obviously, speeding would be another basis to make that stop, and if he had been speeding, then that would be enough probable cause. So I had to question that officer. Why was that not listed in the report? Why is he only mentioning it now on the stand months later, months after the fact? How did he suddenly remember this fact that my client was speeding, even though it wasn't on the dash cam video and it wasn't listed in the report? Well, the judge agreed with me and decided that credibility was an issue here, and she decided that the police officer was not credible in saying that he was speeding. And on that basis, they threw out all the evidence from that stop. Now, you might be thinking that the case got dismissed right then and there, but it actually didn't. The prosecution has to decide to dismiss it, and they also have time to decide whether or not to appeal. And for a couple of weeks, they were mulling back and forth whether to appeal this case, but ultimately they decided not to, and my client's case was dismissed. Now, in the end, this is a great result, and I think it's the right result. We don't want police officers just pulling over people when they touch the lines. Plenty of people who are completely sober, who are not driving recklessly, who are not endangering the people around them, shouldn't just be pulled over by the cops just because the cops want to. So I think it's the right decision here. Now, obviously, your case probably doesn't have this specific issue, maybe it does, but many cases will have an issue here or there that can require a motion to suppress hearing. So it's important that you have an attorney who is looking at these facts, so when there is something that can be challenged, that they're willing to go to bat and have that hearing. Again, this video is all for educational purposes. It's not legal advice, but if you do want legal advice for your case, if you have a pending DWI, visit us at atx.legal. There's a link below. You can set up a no-cost consultation.